believe that if government wants to demonstrate seriousness in the fight against Galamsey, it must go beyond the arrest of Professor Frimpong. It should go wider by ensuring the arrest of government and Jubilee appointees at the heart of government, which includes Mr. Gabby Co, the President's cousin, the Director of Operations, Mr. Lord Comey, including Honorable Joseph Albert Kwam, who have all been cited by the committee. It is our opinion that a public inquiry on the committee reports and damage to our forest reserves is necessary, especially with the now wider destruction of our lands and rivers by Galamsey operators. It is unthinkable that the state, including all its reserves, its lands, rivers, money, people, are left to an elected government to manage. And it turns out that the government itself is a key sponsor of the destruction and misuse of these resources. In addition to calling on the government to institute a public inquiry, we wish to also team up with the eco-conscious citizens of Ghana. Number one, we ask government to revoke the executive instrument EI 144, forest cessation forest reserves. The instrument is 2022. The EI in operation will remove 361.50 acres of forest from Achimota forest reserves, and that's the lungs of Accra.
Right, so the speaker you just saw and heard, Dr. Rashid Pelpo, MP for Wa Central, Ranking Member, Lands and Forestry Committee of Parliament, and he's also the president of the African Parliamentarians Forum on Population and Development. He's right here in the studio. Good morning and thank you very much for joining us.
Thank you. Good morning.
Great. Also joining us, Samuel Atachia, MP, Abuakwa South Constituency and Chairman, Mines and Energy Committee of Parliament. We'll also be joined by Bobby Banson. He's a lawyer and an author as well. He's the author of this book in my hand, Civil Litigation in the High Court of Ghana, by Bobby Banson. Will help us to appreciate some of the laws as far as these matters are concerned. Thank you so very much, Samuel Atachia, for making time to join us also.
Pleasure as always.
Great, great, great. So, you say that the special prosecutor should arrest the people who were named in Professor Frimpong Boateng's report to the president, which got leaked recently. Is it the normal politics, usual politics that you are on, or what?
Well, definitely no. We are very much convinced that the state, the special prosecutor, is aware of the dangers we are facing today, the extent to which Ghana is put in a situation of destruction over years of Galamsey and cooperation by government itself. And if the report is anything of significance, it has led to the arrest of the chairman, the former chairman of the committee on, interministerial committee on mines and illegal mining. And if that significance is placed on Frimpong Boateng to the extent that he is questioned and even arrested, it shows that there is something significant in the report. And the most significant thing is that names of government officials are mentioned, and these names have been seen to be part and parcel of the destructive activities that are going on. So nobody had thought about the arrest of Frimpong Boateng over destruction, over what do you call them, over the machinery, the excavators that, those are just, by the way, how do we get this man quiet? Is the reason they got him. But essentially, they are targeting him because of the report. And the report is touching directly on the nerve of government. And so for
it's not just excavators that the OSP is looking at.
But
it talks about other machines, it talks about vehicles.
Yes.
It talks about even money that was made available to the committee and how it was spent.
Yes.
It talks about gold nuggets.
Yes.
The task force, as it went round, seized gold, among other things. How have they been accounted for?
Yeah.
So the special prosecutor's interest is on corruption and corruption-related offenses in respect of the activities of the dissolved committee.
But what we are saying is this, that this is all triggered by a report done by the committee, chaired by Professor Frimpong. And we are interested in all of that because the people we are dealing with, the MPP we are dealing with, cannot be trusted in all these matters. In fact, it's an indication of how far destructive they have gone. They have taken the excavators, they have corrupted the system, they have taken gold nuggets, they have done everything that is unthinkable by state officials.
If it is not for the populist political purpose, tell us what it is. When the special prosecutor informs the world on the 10th of October 2022 that it was investigating this committee in respect of the issues we have mentioned. And then once Professor Frimpong report gets leaked, they issue a statement again because civil society is calling on them to take the report and take action. And they issue a report to remind us on the 3rd of May this year that they are still on their investigations they began in 2022, and that tens have been invited, have been arrested, so to speak. And as you know, there's one individual from the Jubilee House, formerly, who is fighting to be investigated, to prevent the SP from investigating him.
Yes, yes.
So if you are aware of all of these, and we are told that, but for Professor Frimpong situation getting leaked by whoever, we would not have known that they have been investigating many people. How do you come to hold a press conference to say, arrest ABC?
Samson, it's very simple. These you have elaborated are key and necessary actions that are taken. And we think that by spelling them out and by taking that action isn't much our problem than the fact that the people who had been given the mandate to run this country are mentioned to be key individuals who are involved in all the destruction we are seeing. And we are very much interested in the state itself, the managers of the state itself. I mean, the managers of the states themselves to be accountable for what has happened or what is continuing to happen. And so we believe that by extending that arrest, we would have been confident that government is serious and is doing the right thing. And that's why we are asking for it.
The special prosecutor tells you
yes,
that I have been investigating these people and that no single person connected to these activities will be spared.
Yes.
That they are investigating hundreds.
Yes.
And they have already spoken to or interrogated tens.
Yes.
All of them, no one has gone on self-recognizance bail, meaning they were arrested. No one went without a caution statement.
So we are happy.
Yeah, so why the press conference?
The press conference
all of these?
The press conference is 100% necessary. But we are not against the fact that the state, the investigations are going on. That's not our concern. I mean, we are not against it. We want more investigations to go on. We want more arrests to happen. We want further input into it by subjecting it to public investigation. That's what we are looking for. And so don't appear as if by that press conference we are against the arrest or the significant legal body that is doing what they are doing. We are happy that they are doing all that, but we are calling for further action, and that's very key to us. Arresting Frimpong alone it's not satisfying.
We are back to that.
Yes.
You don't believe the special prosecutor when it tells you, the Office of Special Prosecutor, when it tells you that there are many people involved.
Yes.
Not only Professor Frimpong Boateng,
yeah.
but for Professor Frimpong Boateng's, interaction, encounter being leaked.
Yeah.
You would not have known that many people have been there. And of course, you know of one person from the Jubilee House also, who was also named, and who has been fighting the special prosecutor from arresting him. So what was the need for your press conference?
The need is to create this kind of consciousness we are talking today. Create a situation where Ghanaians are aware that there's a rot happening, state involvement is there, the special prosecutor is working on it, but has not gone far enough. We are calling on him to go further than what he has done.
How do you know that it has not gone far enough when you don't know the specific persons in the tents that have already been interrogated?
The question is, why would he not let us know? And so we have to question it. I mean, you don't do these things as sacrosanct, as if it is a secret. We want everything to be clear. And if it is not clear, we call for it to be clear. It's necessary, and we will do more. We want to assure Ghanaians that nothing should be hidden from the ears and eyes of Ghanaians.
You didn't say
yes.
that we know you are doing your work, but we want it to be public. And if you want a public process, like you said, that is not the special prosecutor's outfit. That's not what they do. Nobody this work, and they present a half-yearly report. Yeah. Until that time is up, you can't be demanding that they should make things public. And they say that we don't make these things public because we don't want to embarrass and prejudice things against the people who appear before us.
I don't think that anybody put the Office of the Special Prosecutor on the table in the press conference we did. We only asked for the further arrest of other people who are key government officials, who are state appointees. In fact, we didn't even mention the special prosecutor in our press conference. We just talk about further arrests to be made, because if you have 100 people committing a certain crime, and there's one criminal amongst them who is supposed to supervise for the crime not to be committed, our key interest must be on the one who is supervising. And we all know the 3 people who are mentioned, who have been mentioned either because of what Armiyawe has brought out Mr. Bisu, or whether what the report has mentioned and mentioned the names, 3 names of Mr. Gabby, Kwam, Honorable Kwam, and then Lord Comey. We want all of them to be brought to the table, to be questioned before the public. So it will serve as a deterrent for other government officials who we suspect are part of this and are not mentioned, to be aware that the public are watching.
We want a public inquiry.
We want a public inquiry. We want to make sure the whole public is looking at them. They are listening to what is happening. The inquiry is made. The truth is brought out. People are questioned.
Want to do this? Not Parliament?
Parliament will not be a key factor in this kind of public inquiry we are talking about. We are talking about a bipartisan public inquiry, which will be set up with key individuals who we know can investigate the matter, the letter, and who we trust will not circumvent the truth, and who we believe will bring out the essence of what we are looking for.
All right.
Yeah.
Honorable Atachia, you heard your colleague, and you have followed their press conference as well. What will be your reaction?
Well, my very good friend, Dr. Pelpo, is struggling to justify the press conference. You see, I'm saying this for one simple reason, that Parliament cannot micromanage a special prosecutor. You cannot sit in the comfort of Parliament and begin to use press conference to stampede the special prosecutor as to how he should conduct his business. That would be very, very unfortunate. And that would be, excuse me to say, an outrageous extension of the powers of Parliament. And the facts are showing a special prosecutor is working quietly, proud to the leakage of the Frimpong report. And the style of the special prosecutor and how he will do his work, half the time submarine work that he's doing, is not subject to a day-to-day parliamentary scrutiny. If not, then the special prosecutor will not be able to do his job at all. And I'm afraid if you said somebody, the special prosecutor should arrest A, B, C, or D of an individual, then it's an unfortunate dictatorship, which Parliament should never dare to do. Because state institutions, we know how to bring them before Parliament when they fall foul of the law and their duties. So I say that it is sad that the minority is trying to push the special prosecutor into doing things to appease them. When you mention Gabby Co and the rest of them, it's all because of the political undertones. For instance, I've just heard him say that the government officials who are involved, because immediately you go that route, then the government should become very unpopular. Now you say you are fighting Galamsey, but meanwhile, your officials are neck deep in it. You know, it is a very convenient way to make people guilty in the space in the court of public opinion, and that is sometimes the strength of politicians, that they'll push issues in the public opinion, so people will look very, very bad, because in the political space, they want to take advantage of the situation. So as far as I'm concerned, if you've never been guilty in the court of public opinion, I have been. And you should be careful in trying to say that government officials who are involved, Gabby Co, whoever, let's leave the special prosecutor to do his work. We've appointed him to do a good job, and let's leave him to do it. We should never stampede him through the power of press conferences in the comfort of a parliament. I mean, to achieve any result. It won't work.
You have said repeatedly that government officials or politically exposed persons, I will add that, who are involved. I think what has to be said is those who have been named in the Professor Boateng's report, because some of them are challenging these in the court. They have publicly denied the report to the extent that it seeks to indict them. But the substantive question to you is, don't you feel that the gravity of the situation actually requires a public inquiry?
Well, I think NDC will be strong to say that the appointer of the members of the public inquiry will be the self-same government. And that kind of ambivalence, with the greatest of respect, I can't accept. So right now, who will be the appointer of the members of the public inquiry? Is it going to be a C.A. Katia or Atachia? So, Council, sometimes I get a bit worried when we want to virtually give political credence to every situation. So now we have the special prosecutor working on the matter. Let's leave him to work. Some people have been named in the document. I'm tempted to come to the conclusion that last week, when I was listening to him, he says he's going to go full length, and nobody's above the law. Let's credit an institution with some credibility that they'll do their work. And if somebody is an MPP man and is neck deep in this matter, he owes it to his office to deal with him. And if an NDC man is also involved in it, he should do equal justice to the case.
The special prosecutor is only looking at corruption and corruption-related, aspects of the Galamsey. the Galamsey menace, including the report. The special prosecutor has been clear. But are you not concerned that the president belatedly referred the report to the police for investigations? And on the side of the police, we practically have not heard anything about what it is doing in that regard, because it is the police that can look into the processes, including the report in full. The special prosecutor will only deal with a small aspect of it, so to speak.
Well, at the moment, we do not know the dossier before the police. And so far as the president has spoken about, I'm tempted to come to the conclusion that the IGP will be very sensitive to the promptings of the president. Again, we'll come back to the same point. Yes, I like the distinction you made. Corruption-related matters will be what is the remit of the special prosecutor. And then the police could go deeper outside that remit. But I'll crave your indulgence. This democracy has institutions undergirding them. We have democracy and we have institutions. So we should say that the IGP will respect what the president is saying and delve deep into it. But if we say that the IGP is quiet over the matter, let's wake him up with a press conference. Sometimes at least might be desired. For all you know, some things are going on that we don't know. And I've told you, and I want to repeat it, it will be very unfortunate that Parliament is micromanaging the dossier of the IGP. That could be very, very unfortunate.
Or the OSP for that matter. Now,
yes.
Dr. Purple, one of your members, Roxanne Nelson Dafiamako, took this matter to Shraj. So Shraj is also supposed to be seized with it. All of that is not sufficient for you.
It's not sufficient at all. But just before that, let me...
Police is investigating.
Let me get back to
OSP is investigating an aspect.
Yes.
Shraj is also seized with the matter.
Yes.
You said it's not sufficient at all.
It's not sufficient because, you see, you are dealing with an exclusive...
It's difficult for people to believe we are not doing the usual politics with this.
Let me explain to you why politics cannot be differentiated from what is happening. The president in 2017 made an announcement that he was going to fight Galamsey. He tied his presidency to it. It was a political decision. The president in 2021 April, took a decision and earmarked some red zone areas and said, look, these areas don't go there to do Galamsey or mining operations. The Minerals Commission, inconsistent with the president's pronouncement, issued about 6 licenses and operations are going on there. The rivers are being destroyed, the lands are destroyed, and the politicians are the same president is keeping quiet about it. Frimpong report is about decisions taken by himself, and the mess in that decision is being reported, and those are political decisions and the repercussions of it. So if all these things are happening, and the public is unaware of what is happening, it is our duty to streamline issues despite investigations going on, to bring it to the fore, so we can sit this way as we are sitting. And again, we can have a public inquiry into it. So eventually, we can have a comprehensive approach to it and a non-political decision about whether Galamsey should happen or not. And I'm happy about the Bono region. The fact that citizens themselves have taken it upon themselves.
The Bebianiha style, Doma style.
The Doma style, have decided that, look, we don't want Galamsey here, we are going to prevent it, and it's working. We can stop it by something even going beyond political decision.
Interesting.
Yes.
But thank you very much, Bobby Banson. Bobby, so the Member of Parliament, Atachia, says, let's not seek to invite Parliament into the OSP's work. By the OSP's Act, in Section 4, even though it begins by saying that the office is not subject to the direction and control of any person or authority, Section 4, subsection 3, says that this, subsection 2 shall not preclude Parliament in the public interest from requesting the office to investigate alleged or suspected cases of corruption or a corruption-related offense involving public officers, politically exposed persons, or persons in the private sector. Do you find that this is what the minority were seeking to do? I'm trying to refine it for them somehow, somewhat.
Good morning, and it's really a privilege to be here with Dr. Pelpo. I've been listening to him growing up, especially on this platform, and Senior Atachi as well. Greetings to him. And if the OSP had not said that he had already started investigating the matter, I believe that the parliamentary request as captured would have been relevant. Last week, I listened to the OSP on your platform, and he made it very clear that before the Frimpong report came out, his office had started investigating corruption-related aspects of the whole Galamsey menace. And so it is not as if the OSP just decided to start investigating based on Professor Frimpong matter. So if Parliament, and Parliament is not only, it's not minority or majority. If the provisions of the OSP Act says Parliament may request the OSP in respect of this aspect of Galamsey, and the OSP says, I am already doing it, then it means that there will not be a need for Parliament to say, okay, we are directing you, because he said, I'm already doing it.
Right.
Particularly when the provisions of the OSP Act says that the OSP is not subject to the direction. Now, I think there are two things here. There's a difference between requesting the OSP to investigate and trying to teach the OSP how to investigate, who to investigate, how to arrest, and who to arrest. I think there are two different things, and I'm sure in the course of the discussion, they would come out clear, because I do not think that it was the intention of the lawmaker that any group of persons or person would be in a position to direct not only OSP, but even the security agencies on how to do their work. That is why even in normal criminal procedure, if I'm a complainant, my work ends when I lodge the complaint and I give the evidence that I have to the police. But as to how the police will do their investigations, even who they will decide to prosecute, is completely out of my domain. If I think that they are not going against the person that I think I want to go, there are procedures that you can follow. So I think that, yes, I agree with the general cry that we all need this Galamsey to come to an end. And if they are politically connected or politically exposed persons who are benefiting from the menace, there should be a system where they will be investigated and properly brought before the law. I also want to link this because Senior Tachan spoke about institutions. You know, when ex-President Obama was in town some time ago and made this speech about Africa needs to establish strong institutions, I have always been of the opinion that it takes strong men to establish institutional framework that will outlive them. I think we saw the dispensation under the former OSP. We are seeing the dispensation under the current OSP. I believe the kind of, for lack of a better word, public bashing that the current OSP has received may vary in terms of nature from what the previous OSP received. But at least we see the public engagement by this current OSP coming to sit on your platform to explain to Ghanaians what he is doing and how, even to some extent, he is doing it.
Two questions, brief ones for your responses. First, you take the view that what is going on so far is satisfactory. There's been a report through the president to the police to investigate. The OSP is investigating the aspects that it has to investigate. And then Shraj is also seized with it. Are you satisfied with that?
I think to the extent that those are the institutions established by law that would have the jurisdiction to investigate, I think that so far all these three have been involved. I don't have cause to think that they will not do their work until such a time where they've brought a report that is being covered by the powers that be, or there's evidence that the powers that be are refusing to cooperate. Then we would have a basis to say that they are being influenced to the detriment of the general populace.
So the minority's request is needless. My next question to you is, so from what you are saying, the OSP, has it been satisfactory to you so far? There has been what you call public backlash. Are they informed, criticism of the OSP, or they are baseless from where you sit?
As a lawyer, without prejudice to all the facts that the OSP has, I was aligned with the public sentiment until I listened to him extensively on your show. That is what I'm saying. I was very satisfied or happy that he decided to do a public engagement through your platform. The whole concept was as if he had just picked only Professor Frimpong and arrested him under Rambo style kind of thing. Then he comes out to say, no, he was invited like other persons that have also been invited, connected to this. I'm doing my work because per his act, he's required to publish a report of his work at certain times.
Half yearly.
Half yearly. And we are not there yet for him to say, this is the report of what I'm doing now. So I believe that we should wait for him to, he said, I started the process before the report came. Let's get to the half year and see the report you provide on this. Then I'll be better placed to say, okay, as a layman, maybe I think he didn't look at it this way, he didn't look at it that way. But until then, let's allow them to do their work. That is my position on it at this stage.
The OSP is facing some difficulties, and one of the reasons we're happy to have you is that, you are good at your procedure and your law. So we want to help you, have you help explain. I'll come to you guys, but I need him to explain a few things. Now, the arrest that we continue to hear, that the Professor Frimpong was arrested. There was what people are concerned about, that the investigator touched his shoulder and told him that you are under arrest. What does that mean? In law, does it have any meaning at all? Was it important for the investigator to touch any part of his body?
Well, I have not seen any provision in the Criminal Procedure Code, or Act, sorry, they've now been turned into Act, or even the provisions of the OSP Act that requires that you are touched before you feel you are under arrest. Or
is that not a general practice? To have a valid arrest, there must be a touching of the body of the suspect.
There must be a form of the suspect knowing that he's been restricted in terms of his movement at that particular point in time. And I believe that over the years, the practice has been, if you touch him to let him know that, okay, you can't move from where you are subject to these conditions, then they can say that, okay, you have been arrested. Now, I believe, because if it was to the contrary, it would have been said, that because per the OSP's position and per his law, when they are inviting you, or they are asking you, let me not use the word inviting, when they are asking you to report, if they intend to arrest you, the contents will suggest that you should do so, you should appear with them, to them with a lawyer of your choice. Because then you know that your statement will be taken. We know that in criminal procedure, there is the caution statement when they are investigating. And when they are investigating, they are finished, they have a prima facie dossier or docket, and they decide to go to the next level of arresting you, giving you bail, subject to further investigations. That procedure is also different. So I believe that when they requested his presence, and they must have told him to come with a lawyer.
Yes, they did.
They did. And I'm sure that the good professor went with a lawyer.
That is so.
And appreciated the discussions that went on there. I always say that the discussion that goes on sometimes in the public domain is as if the special prosecutor has conviction powers. It's as if once he says, I'm investigating you, it means that you've been convicted. But he has the power to investigate. He has the power to arrest and grant bail. So if he says that, okay, we are touching you to satisfy the legal requirements, which may be developed by practice, but I don't believe that an arrest cannot be effected without the touching of the body.
I've actually heard some people suggest that the special prosecutor doesn't have the power to determine bail and say, I'm granting bail and so on. I'm telling you, it's on social media. People are saying, where does he have the power to determine bail or grant bail and say that the man is granted bail in the sum of 2 million and so on? So this is a clear abuse of his power.
No, but the Special Prosecutor Act states clearly that he has all the powers of other security agencies.
Police powers.
Police powers.
That's what it says specifically.
Yes, police powers. And if the police And police can grant police inquiry bail.
That's right.
The law is very sacrosanct. They can do that. So if the special prosecutor, because you see, the reason for the grant of bail is to ensure your continuous cooperation with the officer or the security agent. So in this case, the special prosecutor. So if he says that we are granting you bail to the tune of 2 million cedis, and then we invite you and you do not come, and then they have the right to go to court to have the bail forfeited. It's just a security to ensure that you know that if you do not cooperate, especially with your attendance to their request, then there are consequences. So they have those powers.
Section 28 of the Office of Special Prosecutor Act 2017 says that the officers to exercise powers of police, the special prosecutor and authorized officer shall exercise the powers of a police officer specified in the Criminal and Other Offences Act, Other Offences Procedure Act 1960, Act 30, or any other enactment. So, okay, so that is not in doubt then. Now, the issues that have come up, and you have heard people, very respected people like Professor Stephen Adair, say that Professor Frimpong should not be arrested. He doesn't understand why he's been arrested and so on. But now there's another aspect of an individual that the special prosecutor is seeking to investigate who is challenging him. And in the course of this week, we understood that there was a court process to stop the special prosecutor. Explain to us, by your understanding, what has happened and how that sort of clips the wings of the special prosecutor in this process.
Well, from the, I had the opportunity to read the affidavit in support of the motioners party to secure that interim order to restrain the special prosecutor.
What does that mean, motioners party?
Okay, so the application filed by the lawyers of Mr. Charles Bishop asking the Human Rights Court to restrain the special prosecutor from effectively executing the arrest warrant that they obtained from the district court. So that was the application that was filed. And they didn't serve the special prosecutor to give him an opportunity to respond to it on the basis that their contention was that it was a very urgent situation and the special prosecutor has threatened to carry out the arrest. And so whenever if the court does not grant it for that 10-day period, the special prosecutor may go ahead and arrest, and then it will render the application.
I ask that because, again, in the public, people who do not know are reading meanings into it, that there's a certain collaboration to frustrate the special prosecutor. Is this a normal procedure?
Oh, it's allowed by law.
I can get up and go to court against you without you being in the court and without you knowing on your blind side, go and get an order against you?
Yes, it is allowed per the provisions of our Civil Procedure Act, particularly Order 25, that allows that in very special circumstances where the applicant or the person seeking that relief from the court would explain to the court that if you ask me to go and serve him, by the time I serve him, what I'm seeking to prevent may have already been done. And so grant me this order in the interim. That is why it is an interim order, only 10 days.
10 days?
Only 10 days.
Okay.
That within that 10 days, I will now go and serve him for him to come and respond to the merits of the case. So more or less, restrain him for only 10 days so that I have enough time to go and serve him. Then he can come and respond. That is why the interim order lasts for only 10 days.
Okay.
So if an application, that same process, if you don't file it again without serving the other side within that 10 days, then that process, that order has no force or has no moment after the expiry of the 10 days.
We understand they have gone against a warrant. From what the OSP is telling us, it doesn't appear that the OSP has actually gone to court for a warrant for him in this year. So what do you think is happening? That
was one of my challenges or my queries, curiosity with the application. Because if you read the application that was filed by the lawyers for Mr. Bishop was based on an originating motion that they had also filed in the same court asking for certain reliefs. Now, the reliefs that they were seeking from the substantive relief in the originating motion for their human rights breach were in respect of a purported arrest warrant. And so, remember, previously, the lawyers for Mr. Bishop had issued a writ of summons challenging the OSP's right to even investigate Mr. Bishu. That is one action. Then after the so-called arrest warrant came into public domain, the same lawyers issued another new action by means of an originating motion under Order 67 of the CI court rules to say that that arrest warrant was obtained in breach of the fundamental human rights of Mr. Charles Bishu. So the court should eventually set aside that arrest warrant. It was when they filed this originating motion that they filed the application ex parte. Now, everything about the originating motion and the application ex parte is hinged on the so-called arrest warrant. And so one would have thought...
They call it purported
arrest warrant. Now, one would have thought, as is the practice, that if you seek to invoke the jurisdiction of a court to challenge a process, you must adduce evidence of the existence of that process before the court. Because something you and I know that judges do not make orders in a vacuum. So, for instance, I cannot go to court to say that Samson is threatening to slap me, and so he should be restrained, unless I have provided prima facie evidence of that attempted slap to the court. Otherwise, the court it will be an exercise in futility. Because one of
what you mean, simply put, is that in this case, the court should have seen the actual...
I think arrest warrant, yes. Because the grant or otherwise for an application for injunction, one of the grounds, is whether there is a real question of fact or law to be determined between the parties.
So let's make progress. What happens from here? You said it lasts for 10 days.
For 10 days.
So he cannot, if there is, that is if, if there is any such arrest warrant, it means the special prosecutor cannot execute it.
Yes.
By arresting Charles Bishu.
Based on that warrant.
Within 10 days from that day.
Based on that warrant.
Explain that. What do you
mean? You know, the application filed and the order from the court is restraining the special prosecutor from arresting Mr. Bishu based on that purported arrest warrant. The application and the order did not seek to restrain the OSP from arresting Mr. Charles Bishu. That is not why they went to court. No, if you read the affidavit and the release they were seeking, they are not seeking, we hereby pray the court to restrain the OSP from arresting Mr. Charles Bishu.
So that's why the OSP has issued a statement to say that it has power to arrest anybody without a warrant.
That is so, because it's clearly within the scope of their mandate that they can arrest you without a warrant, just like the police.
Are you saying the OSP can actually go ahead and arrest Charles Bishu?
From the evidence of the affidavit and the wording of the order, in my humble opinion, the OSP can arrest Mr. Charles Bishu if he sees him today, as long as the OSP does not say, I am arresting you pursuant to that arrest warrant.
A warrant.
Yes.
Which we do not know
exists on, because it wasn't exhibited to the application filed by Mr. Bishu's lawyers. And the OSP has also not made it public that indeed we went for an arrest warrant. We have not seen it. So as long as the OSP says, I'm arresting Mr. Bishu, but I'm not arresting you based on that warrant, I don't think the OSP would have breached or would be in contempt of the orders of this court, of the court.
Okay. Yeah. Well, they remain the orders, and until they have been set aside or vacated, it is lawful, and they must be complied with.
In terms of the order.
Interesting. Okay, so just seeking a little education for you, and I'm sure Bobby has helped us in that regard. Yes, there's another concern that the OSP issues wanted, that somebody is wanted, and they publish it. People are saying, this is alien. We are not used to that. What do you know?
Well, like you read in section 28, the OSP has all the powers of the police service in discharge of its mandate. The OSP, in fact, has the power to request a party to be present or provide documents or any other assistance. If that party who has been demanded or requested by the OSP to appear or provide documents or cooperate in any form does not do it, that in itself is an offense. And that is a very unique part of the work or the mandate of the OSP.
It may be that the OSP is getting into the public. Otherwise, if you go to EOCO's, their pages and things, they issue
go
these,
yes. Even the police
wanted notices.
The police do that a lot. If you go to Central Police Station, you see notices. They have a notice board that if a complaint has been lodged, they are looking for somebody, the person has even jumped bail, they have a right to publish it, because you see, citizens have the right to also arrest persons. It's in the Criminal Procedure Code.
Right.
Every citizen, whether a security agent member or not, you have a right to arrest someone. So if you know that this person has been published as wanted, the OSP has told you we are looking for Mr. Kojo Mensah, and you see Mr. Kojo Mensah, as a citizen, you have the right under, I think, Section 8 of the Act 30, to arrest that person and take him to the office, either police or the OSP. And so it is not alien at all for the ASP to publish
OSP. All right.
OSP
right.
to publish
okay,
notices.
So the last thing I'll ask you about, then we move on to something else. I get a quick comment from my other guests and then we move on, is it's being suggested, you've heard some criticism, that the OSP can be used by the government, particularly the Attorney General, who is a political person, because the OSP is not independent, and that the OSP prosecutes on the authority of the Attorney General. What does that mean?
You know, when the Act was in a bill form, that was one of the criticisms that some of us had of it.
Right.
But I cannot say that in the operation of the OSP's office, both Mr. Amidu and the current one, I have any inclination that they may be doing the bidding of the, because they've only operated within under the MPP government. Because Mr. Amidu, it was very clear that he said he was not happy with the corporation, so he left. Now this current OSP, he has gone against certain government appointees. Mr. Bisu we are talking about is a known MPP person. Now, and this is where I think that I am a little bit happy with that provision, if the OSP completes a report and it says, the Attorney General says, do not prosecute, it will be published in his annual report. I expect it to be there. That I completed investigations.
That would suggest that the OSP goes to the Attorney General to ask, should I prosecute or should I not?
Yes.
Is that what the law says? In the preamble to the law, it says that it is to prosecute these corruption and corruption-related offenses on the authority of the Attorney General.
Yes.
Is this not usual in all other acts for these people or offices that must prosecute? Is it not the same in EOCO? Is it not the same for entities that are prosecuting? When they decide that I want to prosecute Bobby, must the OSP take the docket to the Attorney General and say, should I prosecute or should I not?
I do not think in practice and in operation that is how it works. However, the Attorney General, by this provision, can have a right to stop the prosecution. In the EOCO instance or the police instance, if the Attorney General's office writes a letter addressed to the police department and says that bring me this docket, it means you cannot take any step without it. And so the act was very also clear, like you said, on the authority of the attorney, because I think because of the wording of Article 88, that once the OSP will be prosecuting in the name of the Republic, and Article 88 says that it is only the Attorney General that can do that. It means any person that should do that should be riding on the authority of the Attorney General.
So in Ghana, by our Constitution in Article 88, specifically Article 88, is it 1?
Yes.
Article 88, 4. No criminal prosecution can go on unless in the name of the Attorney General.
In the name of the Republic.
Okay.
But that power to prosecute has been vested in the Attorney General. And so you will now be doing it under the authority of the Attorney General. Okay. It doesn't mean that you should go to the Attorney General with every docket, but it also means that the Attorney General can stop you from doing the prosecution.
Right. So what then becomes the meaning of Section 4, subsection 1? It says, except as otherwise provided in the Constitution, the office is not subject to the direction or control of a person or an authority in the performance of the functions of the office. Then 2, subject to clause 4 of Article 88 of the Constitution, the office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offences. And finally, 3, subsection 2 shall not preclude Parliament in the public interest from requesting the office to investigate alleged or suspected cases of corruption and so on.
And so the powers or the government, as we mentioned, there are 3 arms of government. All the powers in Ghana is exercised through these 3 arms of government.
All right.
And so if you say subject to any other provision in the Constitution, one would think we have the executive arm, the parliament, and the judiciary. Of course, the judiciary is not relevant to this discussion. I believe that the 4.1 may have been targeted directly to the executive, that you do not have the executive having the right, because the OSP is nominated for
to direct or control.
Yes, by the president.
Can't do that.
No.
They
However, no, the executive arm of government has no jurisdiction whatsoever to direct the OSP as to who or how it should go about its work. But because of Article 88, which is still in the Constitution, and every other law that contradicts the Constitution is a nullity to that extent.
Okay.
The framers could not have provided for Section 4 without taking into consideration subclause 4. Other than that, somebody would have gone to the Supreme Court to challenge it.
Okay.
That if you say that the OSP is independent...
So the law says you can't control, you can't direct the OSP.
No.
But you say, he can say, stop this investigation.
Yes.
If they do that, is that not directing and controlling?
It is, but that is the Constitution as we have it. But that is where I was going to. That if the OSP faces any such control from the Attorney General, he should put it in his report.
All right.
So that the people will judge.
Thank you so very much. Now, let me take your final quick wrap. Let's start with Atachia. Yes, what do you have to say?
Yes, as Samson, I should say that you're a very clever man, that you brought a lawyer to be in the middle so that what he's saying will not be like this is an MPP manifesto and NDC manifesto. So I have to congratulate you on your refereeing powers. It's very, very, very solid. And what Council Bobby Banson has said is very valid. But I have a problem. My problem is whatever the tactics are, whether you want to use a Maradona of a lawyer in trying to prevent arrest, in the court of public opinion, people begin to ask why what thing has gone there. What not about you? So what I see, and I say clearly, that if you pay regard to the same Constitution, Article 14, 1G, the Constitution provides every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty, except in the following cases, in accordance with procedure permitted by law. That Jesus, upon reasonable suspicion of having committed or being about to commit a criminal offense under the laws of Ghana. So there's no immunity from arrest. So if you have a 10-day spite or whatever there is, I'm afraid you have to submit yourself to the special prosecutor. And then what is needful will be done. My only concern is that people might read meaning into what a lawyer is doing to prevent one person from arrest. Is he guilty? Why is he trying to use the powers of the court to prevent himself from being investigated? So I believe that no matter what it is, eventually there will be an arrest, if that is the pleasure of the special prosecutor. And we should be careful we don't give the wrong impression that, somebody's above arrest. It will be against the Constitution. And then I really want to talk about this direction and control. It's a very, very, very interesting provision, because at the end of the day, as you have really read, the Constitution is clear that every criminal action shall be at the suit of the Attorney General. So therefore, you've posed a very interesting question. What does that mean? If at the end of the day, the OSP wants to go this direction, the Attorney General says, no, go this direction. I don't believe that is a case that you prosecute. That will be the end of the matter. And the way we place meaning on direction and control, probably this matter will have to go to the court for them to give us an interpretation. Because I'm saying you are very, very deep in your saying that when you use this word control and direction, at the end of the day, are you not trying to checkmate the work of the OSP? And by the sheer fact that you do your half-yearly report, would it cure the mischief that a very strong Attorney General will say, look, this case is clear that somebody has a case to answer in court, but I will not give you the power to go and do what you are attempting to do. So I think there's a challenge with this matter, and probably one of these days will be tested in the Supreme Court.
Okay. Thank you for your views there. Yes, Dr. Purple.
Yeah, thank you so much. Let me start by stating very clearly that Parliament or the minority will not be restrained by any investigations of any matter going on if we have a strong belief that by bringing it to the public notice and by making pronouncement of it, investigations will be swift and the public will be interested in the finality of it and that issues will not be swept under any carpet at all. So what Honorable Atachia has said by saying it's not necessary because the investigation was going on, supported by my good friend Bobby, well-informed man, we reject it. We insist that if there's any matter is within the interest of the people, we definitely will have the right to go on and mention it. We have accountability to the people. That accountability goes beyond any other issues that fall outside the wish of the people. Yeah, I mean, we will not be restrained by the will of, to go outside the will of the people.
Right.
And again, because of our oversight role, whether matters are investigated or not, to perform that oversight role, we definitely will often mention these things, as a result of what we are doing, not because others are doing it, but because of what we should be doing. And so our requests touching on increasing the arrests of the people that had been, or of the person that had already been arrested, is to ensure that there is simultaneous investigation in everything that is happening. You remember that, or you know, that when government officials are involved in an issue and they're not tackled very quickly, by the time you realize they have an influence on on how matters finally come into being. So we often will say that, look, it's important that when we are doing this, it is to widen the scope and it is to make sure people don't investigate, don't tamper with the investigation going on.
All right.
And the last thing is that if Mr. Charles Bisu knows that he's not guilty of anything and he's invited severally, he's not going, why is he stopping anybody from arresting him? Why is he saying that the arrest warrant should be offset?
We are a democracy.
Yeah.
And we are under rule of law, due process.
Yes.
Everybody have their rights
to
go to court and assert what they think is right. He's in court saying that he's been investigated on the same or similar matters by police and so on, and therefore the special prosecutor should not investigate him again. Let's leave the court to pronounce on that, whether he should be investigated or he should not.
Okay.
Right.
So for us, going into this matter by the Office of the Special Prosecutor is something of interest to us.
All right.
And we want to work along with the people to make sure these things are properly
We're taking a break, but before we do that, just a quick few of your messages here. And I'm sure that you have been educated also by Bobby Banson in the issues of arrest, the mystery that is being put to being the man's shoulder being touched. In our law, it is called Act 30. It says that for police arrest to be a valid and proper arrest, actually there's a police arrest you can resist. I've used my take to teach you about that. If they don't follow the procedure, you can resist it. And one of the procedure put down by law is that in making an arrest, the police officer or any other person making the arrest shall actually touch or confine the body of the person to be arrested unless there is a submission to the custody verbally or by conduct. So this is law, and I'm sure you are being educated. A couple of your questions. Ibrahim Samani says the OSP's approach to corruption-related aspect of Galamsey menace will not take him anywhere because he can't turn those who sacrifice their lives to be whistleblowers to be his victims. It creates room for the real corrupt people to be shelved. Okay, Little Tete says education must guide us from careless beliefs to morally sound judgment. It must guide us towards logical clarity. More of this education from the OSP will be welcome, in my opinion. Maybe a TV program called Time with Special Prosecutor might enlighten us all. I invite you to the law show tomorrow here on this same platform at 2 p.m. We are engaging two senior lawyers, Lawyer Opokwe J and Musa Ahmed, to just explain the OSP's law to you. So please join us 2 p.m. on the law. Moshood Mohammed said, until we understand that all politicians are members of the same club, indeed, politicians won't stop Galamsey. They are playing a game. Edward Dugbaza says, we are waiting for the special prosecutor to invite Chairman Wontumi and tell him, quote, you are under arrest, end quote, as he did to Professor Frimpong Boateng. It appears Chairman Wontumi already went there himself and submitted himself in the first case. Wise Blaze says, per the article, it is abundantly clear that the bar stops with the Attorney General, and this ultimately will affect the work of the OSP. Derek, 45, says, the problem with this country is how we attach party colors to problems in this country, and the political credence people are giving to the Galamsey war is problematic. And then LGD, Holy, says, we often say, quote, if you fight corruption, corruption fights back, end quote. Can it be said that those fighting the work of the OSP are against the fight against corruption? An interesting question there. Musa Abatwa in Kumasi says, OSP is working, but until he's able to investigate big fishes mentioned in the Professor Frimpong Boateng report, I won't consider his work successful. Going after Charles Bissiou is peripheral. Edward says that when does the half yearly starts and ends? So it's a question. I have the law here. Let me just read. I don't know. I think it's a section 3. Forgive me, I'm going for a break. Section 3 of the OSP Act. Section 3, subsection 3. Subsection 3. Yeah. Okay. Subsection 3 says that the office shall, on a half-yearly basis, publish the following information in at least 2 daily newspapers of national circulation and on the website of the office. A, the list of corruption cases investigated and prosecuted by the office, and B, the number of acquittals, convictions, and cases pending in respect of the cases prosecuted under paragraph A, and the value of proceeds recovered, if any. So I hope that helps. So he says from January to today is the 6th month. The OSP should publish the names of the people who have been invited or arrested. Transparency is the hallmark of every government and institution like the OSP. Since he started the work in October of 2022. Thank you, that's an interesting one. Kofi says, the police were tasked to investigate initial allegations made by the good professor in an interview with GTV. He submitted a report he wrote a couple of years back to the police when he was invited for the investigations. Leaks take place all around with party people denying allegations made against them in the report. Then the OSP jumps once again into the matter. So what has happened to the police investigations? Have they spoken to Prof. Safe collecting a report from him? What about the persons named in the report? The police owe us a duty to tell us what they have done so far. Thank you for those messages. I'm sorry we are unable to read anymore. We'll be right back.